Support from the show comes from Hemmat Law. You need good attorneys or want to join a fantastic legal team, go to hemmatlaw.com. My name is John. Lindsay's name is Lindsay.
Hello.
Welcome to Office Hours, where practitioners and law students come to listen to us, I guess. Today, we have a handful of questions, and then we're going to end with LTBE. As our democracy dies around us, we're going to be looking at bar prep questions and talking about how to be a better practitioner.
Yeah.
Lindsay, how you doing today?
I'm doing okay. We just talked about the news. If you watch our News Without Prejudice segment from earlier this week, there's a lot going on and it's messy. So I'm doing okay. But I'm excited to dive into this. You want to get into some questions today?
Yes, absolutely. I got a few good ones
Yeah.
over the last week. I picked out two in particular. All the questions come from my DMs or emails. I get a lot of inquiries from before we did this podcast from law students and practitioners. I give a lot of talks on AI and how to make your practice more profitable. So we take some of the choice ones that I find entertaining and I give them to Lindsay and then we answer them live.
Yeah.
If you would like to submit a question, you can go to gossipwithoutprejudice.com or you can just find me on LinkedIn, email me. I'm all over the internet. You can find a way to get in touch with me. You guys are smart. What's the first question today?
All right. Our first question today. I'm reading this verbatim, just for the folks at home. Hey, John, I am involved in a litigation matter, and last week I filed a response brief 4 minutes late after midnight. Should I file a whoopsie motion? What do you do in situations like this?
So...
I really enjoyed the whoopsie motion.
By whoopsie motion, I'm probably guessing that it's a reference to Federal Rule 60, which is relief from judgment or order. Basically, if you work in an office where you have CR 60 motions, either state or federal, on template draft, you're in big trouble. But it basically permits getting out of deadlines or final orders for like excusable negligence. What excusable negligence means is up to the circumstances and discretion of the judge. But more to the point of the question, 4 minutes late. So I am of the opinion, reasonable people will differ, that look, this stuff happens all the time. We've had motions that we've gotten in 5 minutes, 1 minute, 2 minutes late. And then the judge receives them and then opposing counsel walks in and says, strike everything that they just filed. It was 4 minutes late, right?
Time to remove all of their power.
Because you see guys come in all the time. Like they come in and after you filed something just a little bit late and they go, strike all of it. They miss their statutory required deadline or orders from the court. Therefore, it shouldn't be considered. They look like an ass, right? My favorite thing to do is I don't even say anything when that happens. Like when our team misses a deadline slightly in a non-prejudicial manner, we let them raise the argument and make themselves look terrible. Because let's say that out loud. You should not be worried because say it out loud. It's like, hey, judge, I know we should really resolve these disputes on the merits of their argument, but they filed 4 minutes late. Therefore, I should win, right? You look like a moron, right? You look stupid. It also, memories are long and opposing counsel will remember that. And when you inevitably need help, it will come to bite you. So the best thing, in my opinion, to do is just 4 minutes late. Almost all the federal and state judges I know will tend to just, as long as it's non-prejudicial, they'll turn a blind eye. Right. So I think chances are you're going to be fine. There are judges who do have stickler deadlines where it's like if it's after 6 p.m., look at standing orders. Sounds like you're in federal court. Look at standing orders for your bench. See if there's anything exceptionally harsh. But it causes more judicial economy to be lost to argue about this stuff than it would be just to accept the damn motion 4 minutes late. So what I'm trying to say is you're probably fine. You're probably fine. No whoopsie motion required. You don't have to charge your client for it or worse right off that time. I think chances are we're going to be fine if we're looking for a bench that's reasonable. But a whoopsie motion. That specific phrasing was something that the gentleman reached out and used. I got a good kick out of that.
Yeah. Gotta read that one verbatim.
It's the same energy as when our I don't think I have a photo anymore, but we had a pumpkin a couple of years ago for Halloween, and so we carved out motion. So there's something called a motion to quash,
Okay.
where you quash a subpoena.
Okay.
Yeah, but it was a motion to squash.
Yeah, of course.
Right. Yeah. So anyways, it's the same sort of energy.
Yep.
I should get a photo of that and post it on my LinkedIn sometime.
Little pumpkin throwback.
Yeah, but man, I think you're going to be okay.
Yeah.
Most things, and even if you're not, most things in the law, regardless of what your partner says, are very fixable. Doesn't mean they don't take effort to fix, but like very few things are irrevocable in the law, and for good reason, right? Courts don't like to hold mistakes of their simple, silly mistakes of their practitioners against the merits of the parties. So that's where I'd come down on that front.
Cool. Well, there you go. The answer is you probably don't need to worry.
Yeah, you probably don't need to worry.
Just wait until they make themselves look like assholes, and then your whoopsie won't be a whoopsie anymore.
Yes. What's the next question?
Yes. All right. Moving on to our next question here. Dear John, I am a fourth-year associate in a mid-sized city considering hanging a shingle. I have a wife and kids and no significant book of business on my own, but I am confident that I have the legal skills. What are some of the top things I should keep in mind when starting my own firm, and when should I expect to make a profit?
So, I mean, the first call out I'd see is no significant business of his own. That would lend credence. So, in general, the more consumer facing your law firm, the less you have to worry about continued relationships, which is both a blessing and a curse. So, for example, family law, none of our clients come back again, if they're lucky. Right. If they're very lucky. A few actually have come back 2 or 3 times. We keep trying to break them of that habit, but they keep coming back. So, but for by and large, continuing relationships are far less important than it would be in like a business practice, where you've got a business that has worked with your office for like 10 years. They send you all their contracts. Your outside their go-to guy. Fostering that continued relationship and good conduct is really important. So what that means is that as your career progresses in certain practice areas, you'll become more and more inherently valuable just because you're in the building and just because you've got more of that business. That's what they reference when they talk about book of business. If you have no book of business and you're a fourth-year associate, that either means he lateraled in from another firm and is completely fresh, or it's more likely, I think, it's a B2C practice. It's business to consumer, right? Not B2B. And that's good. It has never been easier to start a service-based business. You can found a law firm with like $10,000, which is a lot of money, but that's not a lot of money, right? Like that's just a few months of your paycheck if you're frugal. I think it's never been easier, which is both a blessing and a curse. I think a lot of practitioners don't know where to start. And where I would start is find a good marketing agency that you care about. They can fix the business problem. We work with a couple that are fantastic, but keep in mind, not every business is one where not every agency is one that would be good for every law firm. When you would expect to make a profit depends on your objectives. You've got a wife and kids. I'm guessing, fourth-year associate, some sort of family or continuing obligations, maybe elderly parents, etc. That constrains your options. I can share that Clio, Haymarket texting, business SMS, Smith AI for reception service, which is critical, and Teams or Google or the Google ecosystem, one of the two. I prefer Teams. Microsoft ecosystem is standard across the legal industry. It makes it a lot easier to interface with other offices. That's where I'd start, and you would already be head and shoulders above most people. We just finished we should do an episode about this, but we just completed a large study called the Hemmat Trends Report. Only 1 in 7 law firms can text their clients if they're consumer facing, and only like a quarter of law firms can even have e-signature capabilities.
Really?
Yes.
Whoa.
In the state of Washington, anyways.
Wow.
So you would be amazed how easy it is to get ahead of the curve very quickly. Put your head down, do good work, and you'll be fine. If it's possible for you to build a big book of business, do that. It sounds like it's not. Try and find another law firm or someone looking out to strike out on your own if you can, because the more partners you have in a venture, the less risk there is because it's distributed across more wallets. Beyond that, I need a lot more information, but I wish you well, man. That would be fantastic. I wish you all the best success.
Yeah, good luck.
Yeah. I mean, it's business entrepreneurship is really it's eating a heaping pile of shit and asking for seconds. It's really stressful. When me and Steve were just starting out, there were two of us. We had about $30,000 in unencumbered capital, and we really the growth curve is very painful early at the start. Now we've got the margins to basically hire as many people as we like, whenever we like. We've got a flexible marketing pipeline that can expand to any amount of business. We just have to put more money into it. And also have enough time on our hands to let me do stuff like this, which usually means we've got a very efficient system. The secret sauce is in the systems. Most lawyers don't pay attention to it. Most law firms are not firms. They are technicians. And so they don't actually know. They're not businesses, basically. They're just guys doing what they've been trained to do, and they have no acumen or less acumen than they should for the businesses that they run. It's a lot of the reason why law firms are so toxic.
Yeah, I'm sure.
Yeah, I mean, being a manager of people is a skill in and of itself, and a lot of business majors don't have those skills either. So on that regard, I don't blame attorneys. But the law is uniquely stressful, and sort of that pressure cooker comes together, and it really bites everyone in the ass.
I imagine. I highly recommend to our listeners out there who are interested in this subject more to go look at John's LinkedIn and find that trends report, because you guys found some really incredible information there. I was really surprised by how few firms answer their emails. Outgoing email.
Literally no one in the state of Washington is answering their emails or voicemails. Pretty much the only way to get a hold of a law firm is by phone call.
Wow.
For new clients.
I was really surprised to hear that. So go look at some data and let us know if you'd like us to do an in-depth dive.
We should do an in-depth dive. This is not an ad. We don't make any money off the trends report.
Right.
We just do it because we want to know more about our industry.
Mm-hmm.
But you know who else wants to know more about our industry?
Is it me?
Yes, it is. So we're back for LTBE. Lindsay takes the bar exam. Where we have Lindsay take bar exam questions, even though she doesn't know what she's doing.
Mm-hmm.
Lindsay, are you ready for this week's question?
I'm ready to give it my best shot.
Okay, perfect. This is question number something. Officially in my workbook, it's question number 5894. So
okay, 5894.
Who knows if that means anything? All right. An exercise enthusiast signed a membership agreement at a local gym. The agreement enabled the exercise enthusiast to work out at the single gym as many times per month as she liked in exchange for a monthly fee. We're good. 6 months into the agreement, the local gym moved to another location several towns away. The gym sold its existing location to a physical training company. A part of the sale, the gym delegated all of its duties under existing membership agreements to the physical training company. The physical training company's new operating hours were not convenient for the exercise enthusiast work schedule. As a result, the exercise enthusiast never visited the location after the physical training company took over. The exercise enthusiast was dissatisfied and sought to enforce the terms of her membership agreement in a breach of contract action due to the change in operating hours. Whom may the exercise enthusiast sue to enforce her right under the membership agreement?
Ooh.
Wow.
I got no clue. This is interesting.
Exercise enthusiast is a terrible. I had to say that so many times, but that was what was in the question.
Enthusiast.
So.
Exercise enthusiast. Okay. What are my multiple choice options for this crazy question?
Okay. A, only the local gym, because its duties under the membership agreement were not delegatable. B, only the physical training company, because the local gym's duties under the membership agreement were discharged. C, either the local gym or the physical training company, because the local gym's duties under the membership agreement were discharged. Or D, either the gym or the physical training company, because the local gym's duties under the membership agreement were delegatable but not discharged.
Wow, geez. Okay. Can you read me the final question one more time, please?
Who may the exercise enthusiast sue?
Okay.
To enforce her
breach
rights
of contract.
Under the membership agreement.
Ooh, okay. I have no clue. This is cool. So the question that I have right off the bat is the legalities of what the businesses did in the first place of an entire business transferring all of its clients to a different business without notification or consent from the clients. Like, that to me, as someone who doesn't know anything about contracts, that feels like a breach of contract.
Well, we don't have, I'll give you a hint, we don't have information that they didn't tell anyone.
That's true.
And we don't have any information that there was anything in the contract that said they couldn't. Or explicitly said they couldn't. And in general, when you sell or acquire business assets
Mhm.
or an entire business, the
Mm.
obligations and liabilities come along with the benefits of that business. So you're buying everything.
Okay.
And it sounds like a due sale was executed.
Interesting. So who's she gonna sue? Honestly, folks, this is a little bit more of a guess than anything else. But my brain, my logic is telling me that it would be the originator, the one that she originally signed the contract with. Because the question doesn't give us any indication that she signed a contract with the new company. So I'm going to guess, I'm just going to go for it, that she would sue the original exercise company, which, I'm sorry, but I've forgotten my multiple choice answers. Which one is that?
Only the local gym,
Okay.
because its duties under the membership agreement were not delegatable. Delegable.
Delegatable?
Yeah, exactly. Delegatable.
Okay.
Only the physical training company, because the local gym's duties under the membership agreement were discharged. C, either the local gym or the physical training company, because the local gym's duties under the membership agreement were discharged. Or D, either the local gym or the physical training company, because the local gym's duties in the membership agreement were delegatable but not charged. Discharged.
Okay, I'm going to go with that final one. I think that she could sue either of them because it was delegatable but not fully discharged. That's nothing more than a guess off the top of my head, folks, but that's the one that sounds the most correct.
So you're locking in D?
I'm locking in D. Here we go.
Answer D is correct.
Yeah, I did it! That's the first one in a little while.
In general, any contractual duty may be delegated to a third party.
Okay.
However, a duty is not delegable if, 1, the contract specifically states that a specific entity or person must perform. 2, the performance requires substantial skill and discretion that is non-transferable. Or 3, there are other circumstances in which it is clear that the identity of the person rendering performance is a material part of the obligee's bargain for exchange. An obligor is discharged, basically excused by substitution of a new obligor, for example, in a delegation only if the contract so provides or if the obligee makes a binding manifestation of assent forming a novation. Basically, permission or some other such circumstance. Otherwise, the obligee retains his original rights against the obligor, even though the obligor manifests as an intent to substitute a new obligor in the place and the new obligor purports to assume the duty.
Huh. Okay.
So basically, even though you've brought in someone new, you could still go after the first guy if there was specific performance inherent in the contract. Here, the obligee may also have rights against the new obligor as an intended beneficiary of the new obligor's promise to assume the old obligor's contractual duty. So here, she can actually go after either.
Okay. Beautiful. Well, I hope you fucks got that one right, too.
Congratulations, Lindsay.
Thank you.
We have yet another fantastic round of LTBE. This was sponsored by Quimby. Quimby Bar Prep offers study aids, bar review, MPRE prep, and continuing CLEs for legal professionals. Thank you so much, Quimby, for support from the show. Lindsay, do you have any final thoughts or comments on this week's LTBE?
My final thought and comment is thank you, Quimby. This is so fun. And I love that these are such high quality questions that just bewilder me. And
that one, you answered 74% of students got that question correct.
Okay, so that one was a little easier.
Yeah, that was one of the easy ones.
Okay, well, good.
It's very cool to even have a sponsor after only like a month and a half. We have several sponsors, actually.
Yes.
Mostly Hemmat Law and Quimby Bar Prep are our biggest two, but we're actually also, fun fact, sponsored by NordVPN, not a meme. Actually, we joked about NordVPN in our preseason.
Yes, we were like, oh, we should get sponsored by NordVPN.
Yeah, but we are actually sponsored by NordVPN
and we're
now.
so delighted to. It's awesome.
Everybody, thank you so much for listening. Push all the good buttons. Tell a friend. Our data indicates that only about 30% of people who regularly listen to our show are currently enrolled, and we're really hoping to get that to 50 in the coming months. Please go to our website, gossipwithoutprejudice.com. A pledge for as little as $5 can keep our lights on and keep our work moving. If you enjoyed the show, have any comments, questions, feedback, or other thoughts, feel free to reach out to us. You can find more information on our website. And thank you so much. We'll see you later this week.
Thank you. Bye.